Let's take you now to the corridors of justice. The High Court has quashed the Director of Public Prosecution's decision to review and withdraw corruption-related charges amounting to over 50 million shillings against Cooperatives and Micro, Small and Medium Enterprises Cabinet Secretary Wycliffe Oparanya during his tenure as a governor.
Giving his judgment, Judge Benjamin Musyoki termed the move as unconstitutional, irregular and void.
Now, the judge further ruled that the Director of Public Prosecution, Renson Mulele, acted without transparency, accountability, or even consultation with the Ethics and Anti-Corruption Commission, EACC, thereby usurping its investigative mandate.
And as Ruth Wamboi reports, the authority to charge the former Kakamega governor now stands activated.
EACC had moved to court to contest the DPP's move, arguing that the DPP usurped its powers. Justice Benjamin Musyoki, sitting at Milimani's Anti-Corruption and Economic Crimes Division, agreed with the EACC that the DPP's move was unconstitutional. The judge observed that the DPP's July 8, 2024 letter directing the closure of Oparanya's matter was shrouded in misery and worked against public interest. The court also ruled that while the DPP has wide discretion to institute or discontinue criminal proceedings, that power must be exercised within the confines of the Constitution and the DPP's 2019 guidelines on charges. Elsewhere, Milimani's High Court has issued a warrant of arrest against a British national who murdered a Kenyan woman, Agnes Wanjiru at a hotel in Nanyuki, Laikipia County in 2012. Senior prosecuting counsels from the ODPP, Vincent Monda and Gikui Gishu, asked the court to grant a warrant to facilitate formal processes for the suspect's arrest and surrender, since he has not presented himself to Kenyan authorities as he remains abroad.
This court now grants the warrant of arrest as prayed. The court is satisfied that the bundle presented before it.
Judge Alexander Muteti ordered the suspect to be extradited to the Kenyan's jurisdiction and face the murder charges.
Cause to order the arrest of the accused and his surrender before this court for trial. The offense of murder in Kenya is an extraditable offense, and the same satisfies the requirements of dual criminality under Cap 77 of the laws of Kenya. It is so ordered.
Mention of the case has been scheduled for 21st October to confirm compliance. Meanwhile, the High Court has closed and withdrawn a petition over habeas corpus against Tech Guru Ndiangui Kinyage, who had previously been reported missing at his Kino house over 2 months ago. Through his lawyer, senior counsel Mother Karua, Kinyage stated his decision to remain incommunicado stemmed from genuine apprehension where individuals picked by police were later found dead.
The mother did not in any way deliberately mislead the Law Society. She acted in the manner any mother, any relative, responsible relative would when somebody disappears.
While closing the case, Justice Chacha Mwita ordered the police to stop threatening or harassing Kinyage and release his gadgets taken from his house for investigations.
The court has taken into account the second petitioner's concerns that led to his disappearance. He went into hiding for fear of his life, and the steps taken by the second petitioner were not, in my view, extraordinary.
Finally, the interdicted Homa Bay County employee Beatrice Masia Kugo has been charged with assault and causing actual body harm. The charges stem from an incident on September 14th at Lake Front in Homa Bay County, where Kugo is accused of willfully and unlawfully assaulting people, daily reporter Habil Onyango Olo. The prosecution stated that Akugo committed the offense in the company of others who are not before the court.
The accused person is admitted to a bond of Kenya shillings 30,000 with a surety of like sum, cash bail of Kenya shillings 20,000, pre-trial conference on the 30th of September 2025, otherwise remanded in custody.
Ruth Wamboi for Prime Edition.